This is the Cato Daily Podcast for Wednesday, June 1st, 2022. I'm Caleb Brown. In Illinois, a new ballot initiative would beef up the power of labor, allowing some labor agreements to override previous reforms, including pension reform, and even effectively veto acts of the state legislature. Adam Schuster is Vice President for Policy at the Illinois Policy Institute. We talked about the strange and powerful provisions of what's known simply as Amendment 1.
Since the Janus decision in 2017, a lot of public sector unions have sort of, flexed their muscle as much as they could to, I think, convert their political power that they had at that moment into something more long-term, like winning electoral contests that would give people the power of incumbency and maybe get some state-level reforms that would blunt the effects of allowing people to simply walk away from public sector unions. Illinois has what's known as Amendment 1 that is coming up on the ballot. What does that do?
So it's being sold as a workers' rights amendment. That's what the proponents are calling it, the workers' rights amendment. And they're also kind of hiding the main parts of it, because if you ask them what it does, the first thing they'll tell you is it's a constitutional ban on right to work. Of course, Illinois is a state that does not currently have right to work, but this would constitutionally ban private sector right to work from ever happening in Illinois. But that's actually the fourth of four provisions. And the other three that they don't really want to talk about is that, first of all, it makes collective bargaining a fundamental right. So it puts it on par with, freedom of speech, freedom of expression, other fundamental rights guaranteed by the Constitution. Second, it says that all employees, that's part of the first. All employees have a fundamental right to bargain. That's very general, right? Poorly defined. The second part is it says it says what they can bargain over. So it's the things you would normally expect: wages, hours, working conditions, but it expands it to include sort of economic welfare and safety, which opens up a whole new can of worms for unions to essentially be able to bargain over policy topics, right? And then the third provision says that lawmakers can never pass any law to diminish or impair or pull back on those rights in any way. So it enshrines union power in the Constitution to bargain over virtually limitless subjects, and would actually give them the ability to override state law through their collective bargaining agreements. Yeah, which is the contracts the unions negotiate with the government.
So the idea would be that if all employees can negotiate, if all employees can bargain collectively, that it essentially eliminates the notion of at-will employment.
And it also leads to all types of sort of absurd potential consequences. Again, employee is not defined, right? So it doesn't say government employees or give any kind of definition of what they mean by employee. So elected officials are in many sense employees. Prisoners, in some cases, when they're performing work, are employees, right? And so this, could lead to some pretty absurd unintended consequences, including, prisoners trying to collectively bargain, which there's actually been, it sounds sort of absurd, but there's been some, leading indicators that might happen in Illinois, or at least there's groups that want it to happen, or a union of elected officials or something like that, right? So it's a really novel law. Illinois already has some of the most extreme labor protections or special protections for government sector unions in the country. And this would go above and beyond anything we've seen anywhere else in the country. There was one other state where they tried to pass something like this in Michigan. It was overwhelmingly defeated. But no state has a law on the books or in their constitution that would go this far.
So correct me if I'm wrong, but there are some unresolved questions about when the U.S. Constitution butts up against state constitutions.
Correct. So, there's a supremacy clause in the U.S. Constitution that basically says if the U.S. government occupies a space, if they regulate that space, states can't also try to regulate in the same way and create contradictions. And the National Labor Relations Act already establishes the rules for private sector unionization and bargaining. And so by not limiting this to public employees to include the private sector, they're sort of stepping on the toes of the federal government. And we believe that this amendment itself is unconstitutional, and there's a pending lawsuit out there to get it thrown off the ballot.
It seems odd that you would have a constitutional amendment that would tell lawmakers that they cannot abridge rights at all, right? Because if you have a right to freedom of speech, the lawmakers are perfectly free to pass laws abridging speech, and then those laws get thrown out.
Right.
And this seems to go a step further, and I don't know what that means.
I think what they're doing is they really are trying to solidify this for all time and prevent it from being scaled back in any way. And the interesting thing is that the language kind of mirrors the Illinois pension clause, which has given us so many problems. It was put in place in the 1970 Constitution and created all types of unintended consequences. But the pension clause says that pensions are a contractual benefit that can never be diminished or impaired. This says collective bargaining is a fundamental right that can never be diminished or impaired. So it's sort of the old playbook, but in many ways, Amendment 1 would be sort of the pension clause on steroids. Not only giving unions the ability to bargain over more subjects and to override the will of the people and the will of lawmakers, and I can explain that a little bit. There's a section in Illinois law currently that deals with conflicts of law. So if a state law contradicts a collective bargaining agreement, a contract with the union contract prevails. So it overrides the state law. This would elevate that to the level of the U.S. Constitution. And by doing so, it not only can have all types of non-fiscal and non-monetary impacts, but it virtually guarantees that the runaway debt in taxes in Illinois will continue to grow.
I can't imagine that an employer in Illinois would want to contend with an environment for trying to hire and fire employees with this on the books.
Oh, it's already very difficult often to discipline problem employees in Illinois governments. I worked for the state of Illinois for about 3.5 years, and I saw firsthand employees who, exploit provisions in the contract related to discipline. They sort of play the game. The contract allows people to miss up to 5 days of work without notifying the employer previously, with no discipline. It allows you to be late up to 11 times with no discipline, right? So, that's without Amendment 1. Without Amendment 1, the unions have already got so much control over Illinois government. It's almost hard to imagine how it could get worse, but it can. And we've seen in recent years that unions like the Chicago's teachers unions, for example, have been willing to make contract demands that have nothing to do with wages and hours and working conditions and the traditional things that we would expect from a union. And this amendment would just embolden them further, and again, make it so that once something is in place, there's nothing we can do, to pull it back.
Correct me if I'm wrong, because I'm trying to imagine some of the possible circumstances that could arise here. I'm imagining a collective bargaining agreement that is adopted in the future after Amendment 1 is on the books that conflicts with state laws that have been on the books for many years.
Precisely. Our research identified 350 potential provisions in state law that we think are prime targets for the unions to try to override through collective bargaining. But just a couple of the absurd ones, right? And I know these are absurd, but they're still possible, and that's what makes this amendment so crazy. Recently there was a story in Illinois that made national headlines where a convicted arsonist was pardoned and then became a fire chief, right? So the convicted arsonist who becomes a fire chief and later a police officer. That was only able to happen because of the pardon. But if the unions negotiate and say, criminal history can't be used to determine, your eligibility for this position, or if they were to say that, we don't want our employees to have to undergo background checks to work in a school or to work for the Department of Children and Family Services, they could override state laws that are intended to protect children by, keeping violent people away from them. There's just so many potential things. Another one, that I think is sort of fiscal is there's a lot. Illinois has this massive pension problem, the worst pension crisis in the nation, more debt per taxpayer than any state by far. There have been laws put in place over the last 10 to 15 years to kind of scale back on some of the abuses, spiking, double dipping, things like this. But if the union gets in the CBA, something that contradicts, the state law. So there was this loophole where they would exploit unused sick days. They could use unlimited unused sick days to add service credit to their pension. And lawmakers kind of scaled that back to say you can't use more sick days than you have remaining days till your retirement, right? But if the union puts in a CBA in their contract that they can use all of their unused sick days for the pension, that nullifies that state law effectively. And so you could have pension abuses that lawmakers have tried to prevent come back into play because of Amendment 1.
So the power of the purse in the Illinois legislature would be substantially curtailed.
Exactly. And, Illinois politicians aren't the most popular, but ultimately those are the people's representatives, right? And so the ability for unions to override lawmakers in the General Assembly ultimately means that the unions can override the democratic will of the people in this state.
Adam Schuster is Vice President for Policy at the Illinois Policy Institute. We spoke last month in Chicago. Subscribe to and give a rating to the Cato Daily Podcast on your podcast platform of choice, and follow us on Twitter @Cato Podcast.